Hello fellow YouTubers and especially my fellow Australians. My name is Randolph Workers, Papa to my children and Mr. Workers to all those under 25. I will now explain how lawyer Jim committed the crime of fraud, how he swindled everyone that trusted him. Lawyer Jim deliberately blurred two separate development applications into one. After he discovered the property to the west was landlocked due to the 1974 floods. Video 4 of my original series, When Theft is Legal, is a detailed video that explains that as a result of the 1974 floods in Brisbane, the only access to this parcel of land was via a bridge that was washed away over Whitten Creek in Indooroopilly, and that the Brisbane City Council were unable to fund the construction of a replacement. Many of the documents that I am referring to had been removed from the FOI file that was publicly available at the Brisbane City Council in 2008. I filed a separate Freedom of Information application to view the original files at the Brisbane City Council in September of 2012 after the ultimate loss in the Supreme Court. You need to imagine you are in a casino playing poker and you catch the dealer shuffling cards and then dealing from the bottom of the pack when he deals his own hand. That is what lawyer Jim did and how he managed to collect $42,000 in 1988. Lawyer Jim submitted the original complete development application for the subdivision of Lot 2 into 11 lots plus common property on the 10th of March 1987, with a hand-drafted amendment to the plan that depicted another easement area that was never mentioned, purporting to access to the land on the western boundary of Lot 2 after months of negotiations between the architect of the estate and the Brisbane City Council. Lawyer Jim mischievously posted a separate one-page letter dated the 9th of March 1987 to the town clerk of the Brisbane City Council one day previously. That letter was completely independent to the original development application submitted on the 10th of March 1987. During the months after the original application was submitted, and as a result of a council requisition, lawyer Jim had to seek written permission from the previous owner of our land to commandeer his original driveway and in return grant him an easement over the common property or carriageway of the future estate. That requisition was never to be over just part of the common property, but all of it. He was to be treated as an equal within the future development as per the other 11 lot owners. Why else would he give up his own entire driveway, his own land, to only be given minimal access over the common property that went around the entire perimeter of his own land? The letter was drafted by lawyer Jim, which was referred to as the burnt letter. That letter was signed by the previous owner of our land and even boasts a reference number on that letter. Yet it was made to look as if it was drafted by the original owner. The letter was particularly vague and is cleverly drafted to assist in creating confusion if deciphered at a later date. It was pure skullduggery. The original development application for the group title plan was submitted on the 10th of March 1987. The development was granted development approval on the 9th of July 1987. Lawyer Jim then organised his surveyor to draft a separate easement B plan dated the 28th of July 1987 over the original Lot 2 to provide access to the land to the west, knowing that Lot 2 was already subject to a development approval on the 9th of July 1987, just 2 weeks earlier. At the time of commissioning the surveyor on the 28th of July 1987, the landowner to the west had none idea that lawyer Jim intended to offer them an access easement for the sum of $50,000. Neither did the town planners at the Brisbane City Council. The original development approval required 4 metres of green space either side of the original 6 metre main carriageway into the estate. Easement B, as drafted on the 28th of July 1987, was 6 metres wide and was drawn on the western boundary of the original Lot 2. Lawyer Jim knew the same land was subject to landscaping simultaneously. It was a con, as he knew that land could never be relied upon to provide access to the land at the west, as the subject land he was offering for sale was to be landscaped with vegetation as green space, a condition of the original first application. The FOI request of the original documentation in September of 2012 revealed that the landowners to the west were approached by lawyer Jim with an offer to access an easement for the fee of $50,000 over the original Lot 2 in late August 1987. They immediately employed a town planner to write to the town clerk to discover if the Brisbane City Council had forced that easement obligation or request over Lot 2 as a condition of the subdivision of Lot 2, as they had been pleading with the council to rebuild an access bridge that had been washed away due to the 1974 floods. The town clerk replied to the town planner, representing the landowners to the west, that no such condition was imposed on the development approval, and that offer was purely at the instigation of developer lawyer Jim. Lawyer Jim knew the green space of the future group title plan 11-lot subdivision would inhibit a 2-lane thoroughfare over the original Lot 2 he was peddling as his Easement B proposal. The only way access could be sold to the landowners to the west legally is by sharing those funds with the previous owner of our land and gaining his permission. As Lot 1, our land legally owned 50% of the land of the main driveway facing the main street. It is the land that I owned that I decided to fence by placing a steel post in the middle of the road to bring matters to a head in September 2005. Please view video 3 and 4 of the original series. Lawyer Jim, rather than share those funds, chose to blur the two application developments together as one, and then ultimately signed a contract to collect the agreed amount of $42,000, selling access upon registration of the Easement B that benefited the land to the west, and no easement was ever registered in favour of our lot, Lot 1. It was a criminal act of deception, and lawyer Jim was acting as a lawyer, as confirmed by Lexon Insurance when Lexon financed lawyer Jim's proceedings when we attempted to include him as a defendant 23 years after the swindle. One has to ask, why would Lexon Insurance finance this claim? Would any other professional indemnity insurance company anywhere in the world practicing the Westminster system of justice finance a corruption claim against a lawyer 23 years after the event over his own development? The only possible explanation would be is that they knew the outcome before the event. Nothing else makes sense. Lexon Insurance lawyers, lawyer Ben, then sought summary judgment against my ex-wife and I in early 2011, maintaining that the result we had achieved at the end of 2008 was the best I could hope for based on the opinion penned by John Gallagher QC. I, on the other hand, decided to rely on the property report penned by lawyer Bill, as he maintained we were protected the whole time by IPA of 1997. I now know the opinion by John Gallagher QC's main focus was designed to mislead me and my wife. I will come to that in my next deposition video, part 4. After months of fees, the matter was heard by Chief Justice the Jersey, who ultimately decided in our favour, as he maintained our proceedings were far too complex to be dismissed on a simple summary dismissal application, and he suggested we revisit our statement of claim and resubmit an amended version of that claim. I won the case as Lexon's application was dismissed, and we were heading to trial, or so I thought. In the background, within the Supreme Court, both sets of proceedings, our claim against the body corporate and the case against lawyer Les, Lexon Insurance, was being managed by Justice Peter Lyons, a property expert. Lexon Insurance lawyer Ben submitted another application seeking clarification of the judgment by Chief Justice de Jersey, stating he had actually won the proceedings as we had no chance of winning that case, based on the opinion penned by John Gallagher QC and his assistant. It was what was called a notice of contention. Please understand that I'm attempting to simplify into layman's terms a complex story that really isn't very complex, but the legal fraternity profit by making matters far more complex than they need to be. In August of 2011, immediately after our decisive win against Lexon Insurance, Justice Peter Lyons takes control of both sets of proceedings, and the dispute returned to court 4 more times before ultimately hearing the notice of contention application for summary judgment in October 2011. I attended every one of those proceedings, and Justice Peter Lyons kept asking our barrister, lawyer Tom, under what statutory authority are you seeking protection? To which lawyer Tom kept replying, IPA of 1997. I thought it was most unusual, but I now know Lyons was actually addressing lawyer Ben and suggesting an alternative way forward, but neither party took the bait. After 6 months of deliberation, lawyer Kathleen was advised that Justice Peter Lyons would be handing down his judgment, 4th of April 2012, 6 months later. On the date, lawyer Kathleen, my elder son and a close friend of mine, attended the courtroom when Justice Lyons appeared before us and provided judgment in our favour. We were elated. Then, the most unusual thing happened. Our barrister, or lawyer Tom, went to hand up a prepared order requesting the judgment to be sealed in our favour when Justice Lyons refused and stated that he would seal such order at a later date. The date was the 28th of April, was nominated. I noticed weird body language by lawyer Tom, but assumed everything was normal. I had no experience as I trusted everyone involved. Lawyer Ben and lawyer Jackson, on behalf of Lexon Insurance, on or about the 12th of April submitted an appeal application to the Court of Appeal because we had won the proceedings. Now, why would they do that if I hadn't? I had made sure that I attended every court hearing and had penned the 28th of April into my calendar. I suspect the month of April was also used to conduct these proceedings, as it was a month full of holidays, including the Easter 4-day public holiday and the Anzac Day public holiday. It was designed to put us off guard. The reason I suspect this is that the documentation Lyons refers to must have been common knowledge to anyone practicing property law in Queensland, as those documents hadn't really seen any substantial amendments from 1964 through to 1986, other than those included in 1978 and in total the town plan consisted of only approximately 160 pages. Lawyer Jackson had submitted another application to the Registry Office at the Supreme Court on the 24th of April, which was to be heard on the 2nd of May 2012, exactly 28 days after the original judgment of 4 April 2012 in our favour. I now know that our lawyers, Lawyer Kathleen and Lawyer Tom, attended another hearing on the 20th of April 2012 where Justice Peter Lyons sealed an order against us. How is this possible? I mean, we won the case on the 4th of April 2012, as I had judgment to prove it. I stress I trusted everyone involved. On the 28th of April, the senior lawyer, Jackson, appeared on behalf of Lexon Insurance, and the original judgment wasn't sealed or discussed by anyone in the courtroom. And as it turned out, it was never entered into the original court file. I know now that Justice Peter Lyons had no intention of ever sealing the original correct judgment of the 4th of April 2012, and that any thinking, non-biased person without a vested interest will appreciate the obvious. This evidence will be submitted to you in part 4 of my deposition series, which will focus on the corruption and cronyism by Justice Peter Lyons, Lawyer Mark QC and Lawyer Jackson on behalf of Lexon Insurance and the body corporate of Goldersley Park, the day Justice Peter Lyons overturned his own original correct decision against us on the 2nd of April 2012. Now, please like and subscribe to my YouTube or Rumble channel, or visit my website whentheftislegal.org for access to the original 12 videos, and please sign our change.org petition so you can learn just how corrupt the Queensland judiciary really is, and the subsequent cover-up by the Queensland government. These crimes are as fresh today as they were when I first complained in 2015. It is a birthright to be given a fair trial and due process. I didn't get one. Please view and make up your own mind. See you again soon, and always remember, she'll be right, mate. Never fear, Randolph is here. Thank you for listening to me.